Now, this one is going to be a doozy, and there's more than a fair chance of some hate, but I'm going to do my best to try and cover this as fairly as possible and based on my own personal opinions. Don't like them? Don't watch. This video was originally almost twice as long, but I decided to cut out a fair bit of stuff just for brevity's sake. And as I've said previously, you can listen to me, but you should always do your own research and come to your own conclusions. Today we're diving headfirst into the TickleVGiggle saga. Yeah, I know that name makes it sound like it's a really bad porno. In reality, it's a federal court case that may just be one of the landmark decisions here in Australian law. Trans woman Roxanne Tickle sued the women-only app Giggle and its founder Sall Grover after being removed for appearing too manly. The federal court ruled last year in Tickle's favour, finding indirect discrimination on gender identity grounds, awarding her $10,000 in damages and declaring that sex isn't fixed, it's changeable. I disagree with that, and before certain people go absolutely apeshit in the comment, I will explain my views later on in the video. But here's the thing. My views are absolutely irrelevant to this. So according to the court, under Australia's Sex Discrimination Act, which I'm going to refer to for ease as the SDA, trans women are women, full stop. This, in my opinion, has the potential to nuke gender-exclusive spaces both online and offline. But is that progress, or is this just a piss take on women's safety? Grover lodged the appeal, which has just went before the federal court. So stick around and we'll unpack this legal case that left the federal court to determine what is a woman.
Roxanne Tickle was born a man, but now identifies as a woman. But when Roxy joined the female-only app, Giggle for Girls, she got barred. It raised the question, what's it mean to be female? That was answered by the federal court today.
So this landmark Australian court case of Tickle v Giggle for Girls Pty Ltd, which is basically just a proprietary company, was decided in the federal court in August of 2024. The case centred around Roxanne Tickle, a transgender woman who had undergone gender-affirming surgery in 2019 and held an amended Queensland birth certificate listing her as female. In early 2021, Tickle tried to join Giggle, a social media app operating from February 2020 through to August 2022, which was marketed as a safe space exclusively for women. The app used AI facial recognition to verify users as female. Tickle was initially approved, but had her access revoked, supposedly after updating her profile picture. Founder and CEO Sall Grover manually reviewed it, believing Tickle to be male.
So to make it female only, like when we were in early development, it was like, how would you make something female only? And we were just thinking of men in general. You know, if there's not gatekeeping, then it's not female only. So we found out there was this software, like it scans a selfie and says if it's male or female. It's not perfect. That's why we would always have human eyes. The plan was, like this is pre-launch, so the plan was human eyes behind the screens 24/7 because the good old-fashioned human eye can tell a male or a female.
Tickle filed a complaint with the Australian Human Rights Commission, which was unresolved, and then sued in the federal court under Section 22 of the SDA for unlawful discrimination. Grover and Giggle admitted discrimination had taken place, but argued that it wasn't illegal, claiming that it was based on sex, deeming Tickle to be a male, not her gender identity. Now, this is where we get into the nitty-gritty of gender versus sex definitions and terminology, and I genuinely believe this is where the legislation needs to be updated. See, the court, in finding against Grover and Giggle, noted that there were 30 years of cases recognising sex as changeable. But I might argue that many of the pre-2013 cases, which was before the SDA had any sort of amendments, lack sex-gender delineation. I mean, society has evolved. The SDA was originally written in 1984, but it was only amended to add protections for sexual orientation, gender identity, and intersex status in 2013 via the Sex Discrimination Amendment Act. So arguably, it's really cases from 2013 onwards that I would see as being applicable in this scenario, given that the amendments did not exist prior to that. That's not to say that the case law isn't good. I'm just saying I would want to sit down and read all of them to determine which ones were appropriate and applicable.
The judge found is that there's 30 years of legal precedent, legal cases, which have found that woman includes trans women.
I do think that the blanket statement that 30 years of cases recognising sex as changeable might be a bit of an overstatement in my own personal opinion. So the case was heard by Justice Robert Bromwich, who found no direct discrimination based on gender identity, as Grover excluded Tickle for appearing male, unaware of her transgender status. Direct discrimination on the basis of gender identity does require treating someone less favourably than you would others of a different gender identity in similar circumstances. If Grover had known that Tickle was trans and excluded her for that, it might have been direct, but the evidence did not prove it. Justice Bromwich noted, the evidence did not establish that Miss Tickle was excluded by reason of her gender identity, although it remains possible that this was the real but unproven reason. I personally find that commentary inappropriate and unnecessary. He added that the exclusion was a byproduct of a visual criteria failing to distinguish men from transgender women, so no legal discrimination for being transgender occurred. However, the court determined that indirect discrimination had in fact occurred, ruling that the access condition, that is to appear female to an AI or to a human reviewer, disproportionately disadvantaged transgender women who may not align with traditional female appearances post-transition, and finding that this was unreasonable by failing to accommodate diverse gender expressions, violating the SDA protections. Justice Bromwich emphasised that sex isn't strictly binary or immutable. According to him, in Australian law, it can be changed via medical or social processes. The court was also asked to address two constitutional questions. The first question was whether Section 22 and Section 5B of the SDA exceed the Commonwealth powers and the federal government's right to legislate them. Justice Bromwich relied on the external affairs power of the Constitution, being Section 51(29), as Australia signed the 1966 International Covenant on Civil and Political Rights, the ICCPR, of which Article 26 prohibits discrimination on grounds like sex or other status, with gender identity fitting into other status, according to him, granting jurisdiction. The second question was whether Section 24 of Queensland's Births and Deaths and Marriages Act of 1994 conflicted with the SDA under Section 109 of the Constitution, which rules that federal law is supreme. The court found no inconsistency. The laws aren't considered to be mutually exclusive. So what exactly was the upshot of all that legalese? It's that the federal court found that transgender women like Tickle must be treated as women for the purposes of anti-discrimination law. The judge ruled that sex is not confined to binary biological concepts, but is changeable, encompassing psychological and social aspects, and that the SDA's gender identity provisions protect transgender individuals.
I'm pleased by the outcome of my case, and I hope it is healing for trans and gender diverse people. The ruling shows that all women are protected from discrimination.
Giggle and Grover were ordered to pay Tickle $10,000 out of the $200,000 in damages that she claimed for the distress that had been caused to her, plus her legal costs, though this amount was lower than the amount sought due to the non-malicious nature of the exclusion. The decision marked the first time that an Australian federal court had explicitly addressed gender identity discrimination in this context, setting a precedent for how sex and gender are to be interpreted in digital spaces. This is landmark case law being created, or a load of wank, depending on your personal opinion. And just as a side tangent, and for a little bit more detail, Australia's anti-discrimination framework, particularly the Sex Discrimination Act, forms the backbone of these types of discrimination cases. Originally, it was enacted to promote gender equality and comply with the international obligations, like the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, which I'll refer to again later. But basically, it started out banning blokes from being pricks to women in the workplace, and it prohibits discrimination on the grounds of sex, marital status, pregnancy, and family responsibilities. In 2013, amendments expanded the protections to include sexual orientation, gender identity, and intersex status. Section 5 of the SDA defines sexual discrimination as treating someone less favourably because of their sex or a characteristic generally associated with it. Section 5B specifically addresses gender identity discrimination, covering unfavourable treatment due to a person's gender identity or related characteristics. Section 22 is the one with teeth, as this extends those prohibitions to the provision of goods, services, and facilities, making it unlawful to deny access based on protected attributes. This would, for example, include access to a mobile phone app. Exemptions do exist, such as under Section 7D for special measures intended to achieve substantive equality between men and women. But in this case, the court rejected Giggle's argument that the app qualified for such a measure, as it did not sufficiently demonstrate how excluding transgender women advanced equality for women. Speaking on this, Giggle founder Sall Grover has argued that Section 7D was designed to allow female-only spaces for equality, like breastfeeding rooms, which are needed exclusively for women. She argues that trans men who are biologically female might need such spaces and would be allowed based on sex, not gender identity, even if they identify as a man. Grover stressed that Giggle operated strictly on the basis of sex, welcoming women who claim to be men, non-binary, or any other gender identity because their thoughts or identities were irrelevant. It's about biological sex. However, she criticised the Sex Discrimination Commissioner for interpreting the law incorrectly to fit an ideology, effectively erasing sex from legislation and forcing society to adhere to gender beliefs under the threat of punishment, which she sees as terrifying for everyone's right to truth and reality. And personally, I don't buy the court's reasoning on this either. I might be old school in thinking this, but I genuinely am of the opinion that protective spaces should be available to groups. This is about weighing the rights, and God help me for saying this, but the feelings of the individuals. Women should be able to have a space where they don't have to be made to feel uncomfortable, just as men should have the right to have a space to the exclusion of women. People have the right to determine who they associate with. This isn't the schoolyard where little Jimmy is forced to be friends with Timmy because it had hurt Timmy's feelings not to be included in a game of tag. Platforms claiming to be single gender only, be it for men or women, must ensure policies do not indirectly discriminate against transgender women or men, as the ruling establishes that excluding based on appearance or perceived sex violates the SDA unless a valid exemption applies. This could force apps to revise their verification processes, perhaps shifting from AI-based gender detection to self-identification, or risk lawsuits from those that have been denied access. Some critics argue that it undermines safe spaces for women, particularly survivors of trauma, by blurring boundaries, while supporters see it as advancing inclusivity in digital environments. There is a suggestion that platforms might invoke special measures under the SDA to justify exclusions, but that's only available if they prove substantive equality benefits, which the court found Giggle failed to do. Women's rights advocates, as reported in the media, argue that inclusive policies erode sex-based protections, potentially exposing women to risks in physical or digital safe spaces. Trans rights groups, on the other hand, such as Equality Australia, have welcomed the ruling as affirming that trans women are women, deserving of equal access without discrimination. The court acknowledged these competing interests, but prioritised anti-discrimination principles, noting that, in the court's opinion, sex is socially constructed and changeable. Again, Your Honour, agree to disagree, but we'll talk about that later. Now look, just quickly, if you made it this far, I kind of feel like I've already earned the like on the video. It's more important these days than you subscribing, but hey, feel free to do both if you want, or even leave a comment if you're feeling bold. So, why, if all of this was decided last year, am I talking about it now? Well, Giggle and Grover appealed the ruling in October of 2024, seeking to overturn the court's findings on indirect discrimination, damages, and the interpretation of sex. In their appeal, they argued that woman means an adult human female based on biological sex, that sex is immutable, and that the app was a lawful special measure to provide women with a refuge from male intrusion in digital spaces. Tickle also cross-appealed, arguing that the exclusion did in fact constitute direct discrimination based on differential treatment from perceived gender appearances, by treating Tickle not as a woman but as a hostile invader in violation of the Sex Discrimination Act. Tickle's team argued that a female haircut, a low-cut v-neck top and hair down in a profile selfie should have signalled her gender identity to Grover, an argument that Grover refuted by pointing to 80s glam rock bands like Bon Jovi, where men wore lipstick, eyeliner and platform shoes without being considered women, emphasising that what clothes you wear does not confer legal sex protections. Tickle's barrister, Georgina Costello, King's Counsel, which means she's one of the experienced barristers, contended that Grover's willful blindness to Tickle's gender identity, despite her polite inquiries about access issues and presentation as a woman in the selfie, was no defence, as ignorance of a protected attribute cannot shield against direct discrimination and would otherwise undermine the act. Tickle sought higher damages of at least $40,000, including general and aggravated damages, citing Grover's alleged misgendering of her as him in the media, plus finding that there was no evidence of persistent sex-based disadvantage for women in digital environments, justifying the app's policy to begin with. Grover counter-argued by saying that in a free society, Tickle can self-identify as she wishes, but Grover has the right to describe her accurately based on reality, and punishing media comments or witness reactions will chill free speech. Additionally, Grover appealed the original $10,000 in damages which was awarded, and stemmed from her brief chuckle during cross-examination at a piece of satirical merchandise, a scented candle which was not produced, sold, or endorsed by Grover, but promoted in crowdfunding and available on an Etsy store as part of a fundraising effort. It supposedly mocked Tickle's statement on an SBS program where she described realising she was transgender at age 26, due to a dislike of the smell of male change rooms. The lower court judge found the candle so offensive that he didn't repeat what was written on the side of the candle in his judgment, describing Grover's laugh as disingenuous, offensive, and belittling. But Grover's team argued that it was a momentary reflective response protected by the implied freedom of political communication under the Australian Constitution, as it symbolised the subjectivity of gender identity claims. If mockery is protected, then so is the response to it. They therefore said that it was Tickle's counsel's fault for presenting it as evidence. Grover's legal team actually sought to have the SBS TV program admitted as new evidence in order to contextualise the incident, although that was obviously objected to by Tickle's lawyers, claiming a lack of consent and that it wasn't available at trial. Tickle's team dismissed Grover's views as not genuine due to misgendering, but insisted that it's not policing opinions despite punishing expression. What a crock of shit. The appeal was heard by a 3-judge bench of the federal court from August 4th through to August 7th in 2025 in Sydney. Giggle's team emphasised the ordinary meaning of sex as biological and immutable, citing dictionary definitions and arguing alignment with the International Convention on the Elimination of All Forms of Discrimination Against Women. That was CEDAW, and it's focusing on biological women. They contended that Justice Bromwich, the trial judge, erred, which is the polite way of saying that he was wrong, by not considering key evidence of women's needs for single-sex spaces by interpreting sex as changeable. Tickle's team argued that differential treatment based on perceived gender appearance amounts to direct discrimination and that the SDA's protections extend to transgender women without requiring awareness of identity. Honestly, in my personal opinion, that type of argument is a whole can of worms that I find inappropriate. At a base level, I would think that that particular argument could potentially see people liable for accidentally calling someone sir or madam on the street. Giggle's senior barrister countered with a methodical walkthrough of the Sex Discrimination Act's legislative history, arguing that Section 5B requires real likelihood of discrimination, not theoretical risks or hypothetical harms where someone might feel left out, and that Grover was unaware of Tickle's transgender status, reacting solely to the profile picture amongst thousands reviewed daily, and therefore maintaining ignorance as a valid defence since the exclusion was based on perceived sex, not identity. On the Section 7D special measures, the barrister stressed Giggle advances substantive equality for women by excluding non-women, as Parliament intended. It doesn't need to benefit all groups at once or require permission slips from other groups, as anti-discrimination laws involve compromises with edges to make rights meaningful. Justice Melissa Perry pressed the issue on whether protecting women could disadvantage others, to which Barrister Hutley replied that it was Parliament's choice. If the rights can't have boundaries, then they protect no one. He reiterated that the 2013 amendments didn't alter the original intent of the definition of woman as an adult female under CEDAW. Hey, I remembered it at that time. If Parliament wanted to redefine sex as changeable or non-binary, then they could have, but they did not do so. There were several interveners in this appeal, including the Sex Discrimination Commissioner, Equality Australia, the Lesbian Action Group, and various members of Parliament. I'm not going to go through all of them right now. There's a link in the description to the court file website where you can read all of the submissions for yourself. And as I said, make sure you do your own research and come to your own conclusions. But to sum up, the Lesbian Action Group intervened to support Giggle and argue that the previous ruling eroded protections for women and that the terms sex, men and women were based on biology. Equality Australia, the LGBTQIA+ group, stepped in to argue against the lesbians. Grover emphasised that adding gender identity protections in 2013 was meant to safeguard expression, like a man wearing a dress, without redefining sex or allowing men into women's spaces, warning that what she called an absolute disgrace has led to more discrimination against women, alienating them and weaponising the act against its intended beneficiaries. During the hearings, Grover's team attempted to introduce a new grounds of appeal on the first day, but was refused. Discussions in court during the trial highlighted broader implications for women's rights to single-sex spaces, such as shelters, sports, and apps, versus transgender inclusion. Grover's lawyers presented affidavits from women detailing shocking harassment, misogynistic abuse, and trolling by men in other online forums, finding security only on Giggle, akin to women-only gyms where survivors of sexual assaults insist on female-only spaces or forego them entirely. Tickle's team argued that the exclusion from the app was based solely on looks, but during the hearing, Grover clarified that it was biological, settings were relaxed to include masculine-looking women or trans men, biological females, as the app didn't police thoughts or identities. The court rejected arguments that the SDA's gender identity provisions conflict with international law and CEDAW, noting Australia's obligations under international law. Concerns did arise during the hearing when one judge used gender ideology terms such as cis woman, which caused some individuals to take to social media. No decision has been handed down. The expectations are that it could take 3 to 6 months before we get a ruling. The The case has drawn international attention, with parallels to UK rulings like the 2025 Supreme Court decision affirming woman as biological in the Equality Act of 2010. A win for Giggle could restore biological definitions in Australian law, while upholding the original ruling might entrench gender identity over sex-based rights, affecting policies nationwide. One commentator described the entire TickleVGiggle saga as a clown show and dystopian universe, emphasising its far-reaching ramifications for freedom of speech, legal definitions of men and women, and prioritising injured feelings over biological reality, warning that if hurt feelings legitimise damages, anyone challenging gender narratives could face court, as the 2013 amendments erased sex definitions, suggesting men's feelings may trump women's protections. The case raises deeper questions about online inclusivity and anti-discrimination laws' interpretation in digital spaces. The outcome will set precedents for gender identity protections online, self-identification versus biology, and balancing rights in evolving tech environments, potentially shaping policies on safety, expression, and equality for transgender people and women's spaces nationwide. Now, finally, I did say that I would explain my position on the court ruling that sex is changeable, and I'll do it very briefly. If down the track it's a worthy topic, I'll do a separate video. But let me preface this by saying two things. One, that I have family and friends that fall into the various categories of being gay, gender fluid, trans, etc. And two, these are my personal beliefs that I have developed over 35 years of experience on this planet. I am not in any way asking anyone to agree with them, but nor am I asking for anyone else to try and shove their beliefs down my throat, as some have tried before. So for me, I break it down into sex, gender, and orientation being separate aspects of a person. To me, sex is chromosome-based. It's binary, it's a scientific fact, at least until some boffin works out how to rewrite DNA completely. Gender to me is how an individual presents themselves to the world. It's how they feel about themselves, it's how they want to go about living their life. And I don't really have any sort of an issue with that. Orientation to me is really probably the most straightforward. It's literally who sticks what in who and when. And frankly, for me, those three things, being sex, gender, and orientation of another person, are none of my goddamn business. That is, unless you go trying to shove one or all of them in my face. So basically for me, it boils down to what I have said on this channel many times. Provided everyone is over the age of 18 and consenting, people can do what they like so long as they aren't forcing it onto anybody else. Your rights end where mine begin, for example, and all that jazz. So there we have it, folks. The Federal Court appeal for TickleVGiggle. We'll have to wait and see exactly how the judgment comes out, probably in the next 3 to 6 months. I'll probably try and cover it down the track anyway. But let me know your thoughts down in the comments section, or, maybe just leave a like. But as always, stay healthy, wealthy, and wise, people, and I will catch you all on the next one. Cheers, legends.